5 seconds to go. Start. The right of an accused to get a copy of the first information report at an early stage, and also the right to know the allegations as an inherent part of Article 21. Stop. Reference was made to Youth Bar Association of India versus Union of India and another in support of this plea. Stop. Further, as per law, the agencies investigating crimes need to provide a list of all the documents and materials seized to the accused in order to be consistent with the principles of transparency and openness. Stop. It was also submitted that under the CRPC, every FIR registered by an officer under section 154 thereof is to be forwarded to the jurisdictional magistrate. However, this procedure is not being followed in ECIR cases. Stop. Further, violation of section 157 of the CRPC was also alleged, and it was submitted that this has led to non-compliance with the procedure prescribed under the law and the law laid down by this court in catena of decisions. Stop. It was vehemently argued that in some cases the ECIR is voluntarily provided, while in others it is not, which is completely arbitrary and discriminatory. Stop. Para. It was argued that as per definition of section 3 of the PMLA, the accused can either directly or indirectly commit money laundering if he is connected by way of any process or activity with the proceeds of crime and has projected or claimed such proceeds as untainted property. Stop. In light of this, it was suggested that the investigation may shed some light on such alleged proceeds of crime, for which, facts must first be collected, and there should be a definitive determination whether such proceeds of crime have actually been generated from the scheduled offence. Stop. Thus, there must be at least a prima facie quantification to ensure that the threshold of the PMLA is met, and it cannot be urged that the ECIR is an internal document. Stop. Therefore, in the absence of adherence to the requirements of the CRPC and the procedure established by law, these are being violated blatantly. Stop. Para. An anomalous situation is created where, based on such ECIR, the ED can summon accused persons and seek details of financial transactions. Stop. The accused is summoned under section 50 of the PMLA to make such statements which are treated as admissible in evidence. Stop. Throughout the process, the accused might well be unaware of the allegations against him. Stop. It is clear that CRPC had separate provisions for summoning of the accused under section 41A and for witnesses under section 160. Stop. The same distinction is absent under the PMLA. Stop. Further, chapter 12 of the CRPC is not being followed by the ED, and, as such, there are no governing principles of investigation, no legal criteria and guiding principles which are required to be followed. Stop. As such, the initiation of investigation by the ED, which can potentially curtail the liberty of the individual, would suffer from the vice of Article 14 of the Constitution of India. Stop.